You can proceed.
Good morning. I am David Wolf, and along with Alex Souzer, a lawyer with my office, we represent the appellant Joey Garza. The issue before the court today is essentially what is the definition of asportation in the context of a kidnapping. OCGA section 16540A says that a person commits the offense of kidnapping when he abducts or steals away any person without lawful authority or warrant and holds that person against his will in order for the state to prove the essential element of abduction. They must show that an unlawful asportation or movement has taken place. Over the long history since common law, abduction or asportation began as you had to take them out of the state or you had to take them out of the country, and as the law has evolved, it has reduced that movement. And the cases, I think, that are at issue in our arguments and in our briefs are the cases of Love, Harshaw, Woodson, Lepla, and our case, Garza. And those cases run from 1989 through 2007.
Let me ask you, Mr. Wolf, do you think to prevail, you would have to have an overruling in some cases for you to prevail in this case?
Actually, I think to prevail, the only case that would need to be overruled would be Garza, because I think the Court of Appeals in Lepla grasped this court's ruling in Woodson.
But you're talking about this very case, so it's just the reversal of the court. It would be overruling. Judge Stein's question is there any case out there that needs to be overruled?
Right.
I understand, and the point I was making was I think Lepla clearly identifies and implements the holding of this court in Woodson, so that if we were to go with that, the Woodson ruling and standard as applied in Lepla, that in our case, the knocking down of somebody to the ground would not have comported with Justice Benham's opinion from Love that was adopted in Woodson and set out to be the standard.
So you don't think any cases would need to be overruled?
No, sir.
Okay.
I do think that Justice Benham's opinion in Love, where he discussed whether or not the movement such as a positional change was enough and concluded that it wasn't, and where he said from a standing to a supine position is not enough. It must be movement not merely incidental to the other criminal act, but movement designed to carry out or better engage in criminal activity is accurate. In this case, I think what the Court of Appeals has done is they've said that when Mr. Garza came in and struck Ms. Garza on the head and she fell to the ground, that was the asportation, which is specifically contrary to what Justice Benham concluded in Love and what the court adopted, it seemed, in Woodson. In each of those cases, Love and Harshaw, there was a finding that there was another asportation that satisfied the requirements of the code section, but in doing that, particularly in Love, Harshaw, and Woodson, in doing that, the court said, struggling with somebody, shoving them to the ground, is not the type of movement that we're talking about. In Love, when the child was pulled off of the wall, it wasn't pulling the child off the wall that was, in fact, the asportation or alone. It was concealing the child from the view of other people. And in order to facilitate the rape, that was, in fact,
that's when the child was pulled from the top of the bridge down under the bridge to down below the bridge to carry out that.
Just like in Harshaw, where the guy said to the girl, hey, you want to go down the garden path instead of going this way? I can show you a shortcut home. And the girl said, sure. They go down the path. The Court of Appeals said when the defendant struggled with her and threw her into the kudzu and rolled around and fought with her in an attempt to rape her, the Court of Appeals said that was the asportation, while in reality it was the fraud the saying to her, hey, I know a shortcut, why don't we go this way? That was in fact the asportation or the reason that he took her out of the public view and concealed her. But the holding specifically is that the struggle, the throwing her to the ground and the fighting with her in the kudzu is not enough.
How about the tying up in this case? And this is the one that we have.
This is the case where the individual was hit on the head and fell, and her legs and hands were bound, constituting the false imprisonment. After that, it was a sitting endeavor. But tying her up and knocking her down to the ground in this case is very similar to Woodson, where the guy chased the girl around the house with a knife, got her into the bedroom, struggled with her, and wrestled her to the ground. Court of Appeals said that was the asportation, struggling and bringing her to the ground. This court said no, it was when they were in the bathroom and the defendant pointed a gun to her and said, okay, I want you to go into the bedroom. And they went in there, and that's where this court said the Court of Appeals was wrong in saying the struggle and the fight and bringing her to the ground was the problem. It was bringing her from one room to another. Change of position is important. And in this case, what happened was that the young lady was struck on the head, fell to the ground, and was bound and placed in a chair right there. There was nothing to conceal anything from anybody that might have been watching, and there was no substantial movement. It was all conduct that, in fact, the Court of Appeals seems to conclude was the false imprisonment. They say in Section B of their opinion that the evidence was that Garza entered, brandished a gun, tied up after striking Ms. Mendoza, and demanded that she followed the instructions. That was the false imprisonment. After that, they just sat there.
Let me ask you this.
Yes,
you read the statute for kidnapping.
Yes, sir.
And the first part deals with stealing away, what we generally refer to as asportation.
Yes, sir.
There's an or, and the or part is that you have kidnapping where someone warrant and holds a person against his will.
Somebody, I beg your pardon?
Warrant and hold someone, a person, against his will. Do you know what that means?
Warrant and hold the person against their will? It would seem to me that that means, by warrant, I would expect it means that they, my understanding is that they take custody of them and move them and hold them against their will. Well, and hold them. But in establishing those two aspects, the Court of Appeals and all of the other courts, including this court, have concluded that there must be an asportation to satisfy the abducts or stealing away part.
And that's where I'm getting at. It seems to me that we've gotten to where we only look at kidnapping through the lens of asportation, and we've forgotten this provision, and so we kind of force all kidnapping into some minimal degree of asportation without analyzing whether it fits under the warrant and hold provision.
Well, I think that what you're talking about, Justice Melton, is that in order to elevate a false imprisonment, which is also holding a person against their will, to a kidnapping, warranting the additional punishment, is the asportation. That's why the steal away and abduct language, and then you hold against their will, I think you have to have both.
Or it says or. The statute said or.
But I understand your concern because you're trying to reconcile false imprisonment with the or hold such person against his will.
Well, it's lawful without lawful